Plaintiff's motion. Ms. Bailey is present, represented by attorney Julian M. Ferris. The defendant, Mr. Gary Lee Bailey, appears in pro se. Ms. Ferris, you may proceed.
Thank you, Your Honor. This is our motion to enforce and modify the judgment of divorce. Pursuant to the judgment of divorce, the marital home that was owned premaritally by my client was to be sold, and Mr. Bailey was to receive the sum of $17,000 from the sale of the home for his share of the equity. A week prior to the sale of the home was burned down or started on fire, and we filed this motion because Mr. Bailey has been charged with the arson of that home. Today, we wish, though, to adjourn the matter until after the criminal matter to make sure that Mr. Bailey is convicted of that charge, to see whether or not. But in the meantime, we would ask that the personal property that we set out in the motion not be moved or destroyed or changed or wherever prior to us being able to have our motion.
So you're basically just asking the property stay status quo until
the home has been sold.
okay. But the personal property, I think, is what you were referring to, correct?
Yes, we would ask that she not have to pay the 17 at this time, and that all the personal property laid out in the motion just remain where it is and not be sold or disposed of.
Mr. Bailey, do you have any objection to that while this matter is pending?
I do, Your Honor, because
Okay, let me place you under oath, then, please. As best you can, please raise your right. And Mr. Bailey, what is your objection?
my objection is that all the stuff that they have on the list now was my personal belongings before I got into the relationship with Kimberly, and we had divided this stuff up, so I now have this stuff in a storage unit, which is my personal belongings, and I do not believe that it would be fair that I have to sell or hold this stuff until I am convicted of this so-called arson case.
Well, it just sounds like Ms. Ferris is asking that it just stay put where it is right now.
That's fine. I have no objection to that.
That is correct.
See,
Until we can put on the proofs and
Right.
actually ask for what we're asking.
Bless you. Okay. So no objection to that. It just stays where it is right now. Nothing, no one touches it. It just stays put.
No objection to that.
Ms. Ferris presented an order to that effect. The court will grant the relief. And in the meantime, this matter will stay pending, and it can be renoticed when you're ready to proceed with it.
Thank you, Your Honor.
Thank you. That'll be all. Off the record.
Your Honor, would there be any way that I could have a few words with you?
Defendant's motion, respondent's motion, terminate a personal protection order. The parties are present in this case. Ms. Jessica Risky appears on behalf of Patrick J. Gola. Will both Mr. and Ms. Gola please raise your hand? Burden of proof of continuing a personal protection order rests upon the petitioner, Ms. Gola, so she has the burden of going forward in that. But part and parcel of this, there's a motion for temporary relief, and I believe by reading the file, Mr. Gola is requesting to be able to return to his own home as well, correct?
Well, so I will give you a brief rundown of kind of what I believe will be a little bit easier to break apart all of this. Mr. Gola is currently on probation in the district court for 18 months. There is a no contact order, which will be in effect for that entire 18 months. He will not be eligible for an early discharge from probation or anything of those sorts. Okay. The date that this ex parte motion was filed was also the date that Ms. Gola gave a statement to the prosecuting attorney that was used at his sentencing, which was he drove by the house a couple of times. Then we had received this when we were here again for the motion for temporary relief. I still have yet to receive a motion or a response to that motion. The issue is that home was purchased 12 years ago, well prior to marriage, by Mr. Gola. He owns that home, and you know, we resolved the criminal issue and we filed the judgment of divorce. They have no minor children. It was filed back in April. Within 3 weeks, that divorce decree could be entered by this court. So yes, we would like to get back into the home. There are taxes that are due. There are things that needs to be done. And according to her answer, there is, you know, she would like the property that she has, the vehicle that's in her name, her name prior to marriage restored. I don't really think that there's a lot to fight about here. And 18 months is much longer than the 12-month PPO to me, it feels like this is a way to circumvent, I can continue to stay in this property and drag that out. And so, there's a multitude of those things, Your Honor. So again, and not only that, when you're on probation, I mean, there are significant issues that could arise should you violate any of those terms. And this county would take that very seriously. So he's complied with the court orders that we've had so far. And again, we're requesting the termination of that PPO is not needed because we have it intact until at the very minimum, October of 2025, which would have been longer than this. Get moving on this divorce and have her vacate the home so he can return to his home.
Mrs. Gold, do you have any comment?
I can prove that he drove by the house numerous times. I have him on camera.
All right. So what about the status of the divorce though?
I want a divorce.
Okay. What about the home?
The home, I'm only staying in until I can live somewhere else. I have nowhere to go. I can't save any money because I'm paying the bills.
Okay. The divorce can be heard when, Ms. Risk?
It was filed April 17th, so the 60 days would be June 16th, I believe. So, like I said, within the next 3
Over
weeks.
2 weeks.
Yeah.
All right. Well, it sounds like we have a motion to terminate personal protection order. You're under oath, Ms. Gola. Explain to the court why you feel that the personal protection order should be continued.
Because I feel threatened. I'm scared for my life. This is not the first time that he has been hostile towards me. There's many instances, and just because I didn't go to the police doesn't mean it didn't happen. But I have made police reports. They have a stack of papers about this big of text messages of him threatening himself and to commit suicide, sending me pictures of his gun.
Your Honor, I understand that she's representing herself in pro per here, and I get that she can have the narrative, but she's referring to things that aren't in evidence that I've never seen. So I would just ask you to take that into consideration.
What do you mean not enough?
Text messages. She's saying they exist, but if they're valid text messages, then we would have them.
I haven't seen them yet. I'm just hearing this. Objections noted. But let's go.
Any evidence, if need be, I can get it from the police.
Okay, well, you need to have it here today, though. That's the issue.
I didn't know that I needed to have it here today.
So you're not ready to proceed? I mean, today's the day. I mean, no disrespect, but when they file a motion to terminate a personal protection order, it is your burden to establish that it needs to be continued. You have to present evidence to that effect. So do you have any evidence to indicate that today?
I didn't really think that I needed to have any. Like, I'm doing this on my own, so.
I see. Anything else you want the court to consider?
We have gone to trial before, and he won. And I will admit that was partially my fault that he won because I let him get to me. And obviously because I do care for him, and I have.
Cross-examination.
Your Honor, I don't have any.
Do you wish to present any other witnesses, anything like that?
No.
Ms. Resky, do you wish to present any first?
No, Your Honor, I believe that the burden is on the petitioner, and based on the fact that there is already a valid no contact order, and based on the lack of evidence he's able to provide into any type of specific anything, we believe that the PPO should be terminated. There will still be a valid no contact order in place. Therefore, there is no reason for that.
From your experience on the road, if there is a pretrial release order that's in the lien system, and you encounter an individual who allegedly may be in violation of it, how does that compare to the situation where there's a personal protection order filed and there's an allegation that's violent, from your experience?
We tend to treat it the same, my experience.
And in your situation, for instance, let's say you have firsthand knowledge of a violation. What is your normal course as a law enforcement officer, if there's a PPO?
Confirm it's valid and proceed. Or make an arrest on it.
Okay. And what about the PV allegation, probation violation allegation?
Try to contact the prosecutor's office and give them what evidence we have or first knowledge of it.
And if the same facts were to apply, would you arrest them normally in that situation as well? Okay. All right. All right. The petitioner in this case, Ms. Gola, has the burden of persuasion in a hearing held on a motion to terminate or modify an ex parte personal protection order. That's citing the Pickering case at 253 Mishap 694. So under MCR 3.310B5, the burden of justifying continuation is upon the applicant. In this case, I've heard the testimony of the petitioner that she feels threatened. She made statements regarding a vehicle driving by, believing to be the respondent in this case, and she's scared for her life. She did make reference to text messages, though the court does not have them in front of it at this time. And unfortunately, this is the time and date for the hearing. You have to have your evidence ready to proceed, and I don't find any good cause in adjourning. So as a result of this matter, and plus there is a valid pretrial release order in effect, which I'm assuming there's to be no contact at all, or even indirect contact.
There is no contact, no indirect contact, no direct contact, no third party contact. He is not to enter a premises where she is. If she were to enter a premises where he is, he must immediately leave. There is none of that. And based off of that, he cannot, in any way, shape, or form drive by the home, or not drive by the home, but enter the home. We had already addressed this with Judge Harrington when we said yes. He had driven by a couple of times when she was not there to check on the property and the lawn. That was the issue. And he was already warned by Judge Harrington, okay, I understand that as an individual, you're going to make a loop. And mind you, this property is located like not even barely a block from the Seaboyne Police Department. So this would definitely, be watched and monitored. He has no reason to drive by now. We've already addressed all of this.
The Seaboyne Police doesn't sit in their office all day.
Well, no, Your Honor, but the only other times that he had even driven by, we had reached out to the Seaboyne Police to, hey, I'm going to drive by to check on my property. He's also accompanying him back to the home to retrieve some property that Ms. Gola allowed him to come in and get. And this was prior to all of this. So those things I think are necessary to be considered.
Ms. Gola, you raised your hand.
Yeah, and I think it's necessary to know that when I parked up front. He drove by me, he seen I was up front and I was sitting out there and he deliberately came around this way to walk by.
I was also parked 3 cars in front of where she was, and Mr. Gola knows my vehicle, and I told him to look for me because I would be here approximately between 8:45 and a little after 9. Then he ended up having to text my work.
Well, but no contact or indirect is no contact. I understand that, but we're going to dismiss the personal protection on the basis that the burden of proof has not been established in this case, but the pretrial release order is still in effect.
I have orders if I can approach on.
You may, and let's go to your motion then too.
Your Honor, I guess I would just request that you obviously take judicial notice of what we had just done here.
Sure.
And the fact that the judgment of divorce was filed on the 17th of April. It can be, finalized very soon. Mr. Gola currently has to pay $600 per month in order to reside elsewhere. Whatever remaining bills like we can handle, but he needs to get back into the home. And the home was purchased 12 years ago. The parties were married in April of 2023. She did not move into the home until August 1st or until August of 2023 after she was evicted. She put that in her pleadings. And so she'd only been staying in that home like full time with Mr. Gola for approximately 4 months. And it's now been over 5 months that she's been residing there. There has been no change in equity. There's been none of those things. So we would ask that Ms. Gola have to vacate the home that was Mr. Gola's prior to marriage, and that we can get this divorce going and hopefully finalize within the next few weeks for both of these individuals.
Ms. Gola, you're responsible.
I don't want to keep the house. I'm not trying to get the house. I'm trying to stay there until I can find somewhere else. He has not been paying the bills since this happened, and they've all been put in my name because he lied to the electric company to have them shut it off. And Officer Repke had to come up there and verify what I was telling them was the truth. So the internet, the gas, the electric, I have been paid for lawn care, all of that. It's all in my name because he was not paying it.
Okay. And so what do you want to do regarding the status of the home right now?
I just want to stay there until I can get somewhere. I have nowhere else to go yet, and I haven't been able to save up any money to get in anywhere. because I'm paying all the bills and taking care of all of the animals that he has not inquired about or anything.
Your Honor, Mr. Gola is unable to inquire about said animals because there is a no contact order. There are a few animals that are his, but as a result of what had happened, he had to leave. He cannot enter a premises where she's at, right? And she also has, I believe, like 4 or 5 of her own. Well, I guess like 4 cats, a dog, and a couple snakes. So, I mean, he can't inquire about animals, and I mean, we're going to treat that as property anyway. In a divorce, that's just what happens. Unfortunately, even though we care a lot about our pets, he's unable to do that. He can't communicate with her about bills. He paid a number of bills. She took it upon herself to change what she needed to change. And there isn't anything that we can do about that because she's still there. And without any of that proof, without any proper foundation and the ability to authenticate that, a lot of what she just said is hearsay.
That she put the bills.
No, I'm in regards to Chief Repke verifying something. I don't know that Chief Repke verified something because Chief Repke is not here. I don't know that he lied to the electric company because there is not a representative from the electric company here. That's what I'm here.
So you're focusing exclusively on the home pet, correct?
I am focusing exclusively on the
Okay,
home.
in your motion, I just want to make.
Well, and there were a variety of things, and she alleges that there, and again, I didn't receive an actual answer to the motion for temporary relief, but she does bring up some of the things in regards to what was stated in there in her answer. So she states the car keys are in the house. He's not going to the house. He cannot go into the house. Those are the things. So I think it would be very simple. She can make a list of all of the property that she needs access to. We can make sure that that happens. I believe we could probably get some assistance from someone in the village of Sebring, to an officer to be able to facilitate that. And she can get what she needs. And again, this divorce can be finalized in a matter of weeks.
All right, the court's position on this is the proposed motion to return to the home is granted, but not so for 30 days. That'll allow 30 days time for Ms. Gola to take care of her affairs, not only to find another location, but also to take care of the billing issues as well. And if they're not resolved by them, that certainly will be part of the divorce trial on that proceeding. But 30 days from today's date, Ms. Gola is to vacate the home.
Thank you, Your Honor.
President, as I understand it, and Ms. Hill can correct me if I'm wrong, but you're not requesting to proceed on your motion.
No, my team is going to be picking that up, and that was rescheduled for July 26th.
Okay, great. So what we have here, Mr. Koth is alleging denied attorney time. And I'd like that both parties please raise your right hand. Thank you. Oh, I'm a little confused here. What is the weekend you're asking for? And then my next question will be, well, whose time is it supposed to be?
The weekend, Your Honor, was weekend before Memorial Day, which would have been the 17th of May. It was my weekend. Because I was supposed to have them the 3rd of May. But the month, or this week of April, I was receiving a couple text messages through my daughter's phone stating that the 3rd weekend, or it's the 3rd day of May, which was my weekend, that the children were going to their stepsisters to get haircut appointments because their stepdaughter also moved into another apartment. She was going to take my 2 children shopping for football cleats, stuff for softball. I said, that's fine. I will make up another weekend, but I'm not changing my schedule. So then,
So you voluntarily gave up?
I forfeited. Me and Miss Hill agreed that we would make up another weekend. So it is, I didn't screw up my schedule because when I don't have my children, I make plans.
Okay.
So we agreed upon working out another day without screwing up the schedule.
All right, but you contend though May 17th was your weekend.
Yes, it was, Your Honor.
And what happened that you believe you were denied parenting?
Because that weekend, my children had stuff going on, and she did not think I would take my children to these events. My son, youngest son, had a birthday party out at Charlemont Lanes in Cass City at 4 o'clock until 6. Then he had flag football on Sunday, which would have been the 19th. She kind of thought that I would not take him to these events.
Okay, you thought, but is that what was told to you by her?
Basically, it's, everything is all on here, stating that, well, let me see here, Your Honor. It says on here on May 9th, which she did give me an ad close text. It says, if you are unable to take my son, Hugh, to the birthday and there are no buses that come to Cass City, and then there's an Uber or a taxi service out of Sandusky, you would have to arrange for that.
Okay. So, according to your testimony, you intended to take the child.
Absolutely, Your Honor. Absolutely, I did.
Did you have the opportunity to?
No, because I was denied. I was denied the whole weekend.
Did you receive any notice?
No, I never received no notice at all. I even called the Family Transit that Friday and asked them if there was busing scheduling, and the lady told me no, there was no busing scheduling at all.
Okay, before I go to Ms. Hill on this in response, this is your matter, correct?
Correct, Your Honor.
So, according to Mr. Cole, this is supposed to be his scheduled weekend.
The 17th, the 19th?
Yes.
Yes. That is what he had filed for his alleged parent time. Before that had come through, Your Honor, we had received an email from Ms. Cole stating, Ms. Hill, I'm sorry, stating that she did not deny him that there was a switch in a weekend at some point before the 3rd. So there was a little bit of confusion as to specifically whose weekend is who, which is why the notice appeared for lunchtime parent time separate day. Plus their existing order did not have a baseline date for us to actually say whose weekend for sure was.
Okay, so without a baseline date, we really don't know.
Correct, which is why the notice appeared testimony of parties was scheduled.
So regardless of what happens today, do we need to set a baseline date here?
It would be beneficial for the future.
Okay. Ms. Hill, your response.
Mr. Coates did agree on the forfeiting of the weekend of the 3rd. I then offered him the following weekend so he could still have his consistent time with the children. His response back was, I make plans when I don't have the kids. I said the thought that the next weekend, which would be the 17th, was actually my weekend because we got it a sync back in March, where he had only had them one weekend due to illness, not only with him, but with the kids. And we tried to rally back and did so for the month of April. I stated that I would be willing to agree to the 17th. I'm sorry, let me back up. I offered him the 10th. He denied that because he said he has places to go and people to see, and he makes plans when he does not have his children. I said I would agree to the makeup of the 17th if you could promise me that the kids would make it to their scheduled functions. My daughter had mandatory tutoring on Saturday because she struggles in math and she needed those makeup credits or tutoring support in order to move on to the next grade. My son had already made plans before that for a birthday party that he was going to attend, and he had practice and a game on Sunday. He said, remember I told you back in my previous conversation, when I forfeited the weekend of the 3rd, I will pick the time, I will pick the day, it will be my decision. According to our divorce decree or our divorce judgment, he needs to provide for makeup weekends 21 days notice, and both parties need to agree. I stated that I would agree if he could promise me that he could make sure that they attended all these. His response back was, my work is my priority, work before play. I am a very valued employee and I get called in at all hours of the time on the weekends. I can't promise that I can do that, but you can arrange for the TAP bus for transportation both to and from for all of these events. In order to do so, that would require me to do 6 trips from Tuscola County to Stacks, which is where our meeting point is because of the mutual restraining order. We've never gone to each other's homes. On Sunday, there is not a bus. So I would have to either do an Uber taxi or figure out how I would get him, because I cannot go to his home to get to practice his game, which would end roughly between 12:30 and 1, and then make it back to the Bad X location where we do our exchanges. And all the time since we have been divorced, and 2.5 years, he's been very unpredictable when it came to any transportation. He's always said, you made the arrangements, you did the transportation. I'll take the kids this weekend, but you provide all the transportation. 6 trips over the weekend, on the weekend that wasn't even supposed to be his. This was a demand weekend that he wanted. Didn't really seem very, let's see, not doable, but it didn't really seem like that made a lot of sense. They would spend more time on the road than they would spend with him. So then I replied to him that I did not agree for this makeup weekend, that I would take the responsibilities because he's never been predictable or dependable, nor have the people that he has requested that would be willing to help for pickups, drop-offs, or exchanges. They've either didn't show or failed. Academics, the main thing was the academics, that tutoring was required for my daughter to maintain those credits. And I didn't want anything to jeopardize those. Plus their plans are as important as ours. These social events and things that they want to attend, why should they be less important than a demand for a makeup weekend? So I took all of that into consideration and told him that I didn't agree for that to be a makeup weekend, but Memorial weekend, the following weekend, would be his holiday. If he would like, he can have them extra days and go from Friday to Tuesday instead of just Friday to Sunday, and then he's there is getting extra time. His reply back at that time was, I have plans, so I won't be able to take them. About a week later, roughly, without looking back, he did agree to take them, and I left it at that. He came back probably before Memorial weekend, stating that now he also wanted the last weekend, which he hasn't brought that up yet, of the month, which was my scheduled weekend, which would be today. And the kids already had plans for, like they did last year, it's their end of the school, doing their park has all kinds of events, and we have a sleepover at our house.
So you believe the 31st would have been your weekend?
Yes,
Okay, so Dave gets alternate weekends.
typically, except for when we get on a stink, which is that when
Oh,
he
wait,
wins it.
wait a moment. What do you mean by typically? What does the judgment say?
It's typically every other week, but there's been times where he's approved forfeited weekends with the kids.
Well, sure, but even he may say, I can't take the children, I don't want to take the children that weekend. It's still his weekend. And then your weekend will be the weekend after that, moving forward, when you agree.
Normally, that's what it is. But like I said, he didn't give me a set date when he wanted his weekends to resume. His response was, as I stated, I will pick the weekend of my choice when I want. But I've been in court before when I requested a weekend, and our judgment says he needs to provide 21-day notice, and both parties need to agree.
Further back to Mr. Koch, it's alternate weekends, and Mr. Koch was supposed to have the children on May 3rd. He should have had the children on May 17th. I mean, just common sense. And it appears that he would have the 31st as well. Correct.
If that's what the schedule they were following, but alternate weekend.
Right. So let's back up a little bit then. The weekend of April 26th through the 28th, where were the children?
They were with Miss Hill.
The 26th through 20th of which month?
April.
Of April. I believe so, without looking at my calendar, which I do not have it with me.
Okay. The weekend before that, the 19th through the 21st, were they with you, Mr. Koch?
They were with me, Your Honor. How it is, I knew that the kids weren't with me on the last Saturday of April. I was on a side-by-side run out of the village of Port Austin. So I know that for a fact.
And prior to April 19th, the April 12th weekend, children were with you.
I believe so.
And then April 5th would have been you.
Right, Your Honor, there was an incident where I did have my children one weekend. I did get this from the prosecutor's office, which was on May 2nd. Had to call the Huron County Sheriff's Department. It was a weekend that I did have my children. My oldest daughter, who kept on hounding me all day long, all evening long, and you yourself even told me don't discuss financial situations in front of the children. And I'm holding to that guns, and she kept on bothering me about some financial situation to do with driver's training.
Well, what does this have to do with?
It was a weekend that I had the children, that they were extracted from my house, from the Huron County Sheriff's Department. It was their best knowledge.
And when was this?
It was in April sometime, Your Honor. It might have been the 12th. I tried to find a police report. I could not find it.
Okay, because what's confusing here, the parties have alternate weekends, and I've asked the parties who had the weekend prior to, it would stand to reason that Mr. Colt had the weekend of the 17th, and it appears he'd have the weekend of the 31st. Except as the holiday changed things.
Parents have them continue as a fine rule.
So they don't have the holiday schedule.
That was a court order for me.
They do, holidays supersede the regular schedule, but it continues as if uninterrupted. So if they have, as an example for Labor Day, if Dad had the weekend prior and it was his holiday, he would have the weekend prior, the holiday, and the following weekend schedule continues as if uninterrupted.
See. And you have you're claiming to have the children this weekend.
I want to back up to the previous conversation. Did he not just say, just so I'm clear, the last weekend of April, he was on a side-by-side run?
And that was your Saturday.
Okay, so then if that was the last weekend of April, his next weekend should have been the 10th, not the 3rd. I don't have a calendar in front of me.
No, you had him the last.
I'm just clarifying that with you.
Either of you need to talk to each other. Mr. Davis, can you hand that calendar over to Ms. Hill?
Of April would have been, according to this, if he had a last weekend, then the 2 weeks later it should have been the 10th and the 24th, according to what I had. So that's why.
I don't understand.
You said the last weekend of April. Okay, we're in May. This is May now. So the last weekend of April, he did not have the children.
Let me ask you this way, so that it's more clear in my head. So he did have the children on the weekend of May 3rd, right?
No, he forfeited that weekend.
Right, but I'm saying that was his weekend.
Right.
According to what I had, it wasn't, because the last weekend of April, he was on side-by-side one. That's why he didn't have them. So the next weekend that I offered would have been the 3rd, but he had made an agreement with my daughter over the phone not to take that weekend to forfeit it because they wanted to go to their stepsisters. So I offered the 10th, so he would be able to still have a weekend in there and wouldn't have such a huge gap in between, which should have been my weekend, the 17th. His holiday would have been, and weekend would have been the 24th, which I gave extra days to the 27th, and he took them to school, which would make my weekend this weekend.
That wasn't the testimony earlier.
That was, I didn't have the calendar in front, that's why I said I'm uncertain without having the calendar in front of me.
So why would he forfeit a weekend he didn't have?
I guess you'll have to ask him that. I don't know what Mr. Polk makes his decisions. When I
You're
offered
claiming
it,
he wasn't supposed to have children on May 3rd.
because I offered him a makeup weekend, because not only did he get behind in March, but I offer him extra time when I can, because the only time Mr. Polk sees the children or attends anything is on the scheduled weekends in the 2.5 years we've been apart.
Right, and that's what I want to know specifically, the scheduled weekends. It would appear that May 3rd was a scheduled weekend for him, because he wouldn't forfeit it if he didn't have it.
It was supposed to be a makeup weekend from where we fell behind in March when he only had them one weekend. And I confirmed that with my transportation at the transit. They only went one weekend. And where things get confused is he has a lot of conversations verbally with my daughter and then put something different on app close. I even forwarded it to Mr. Holdwick. I sent him a July and June schedule so we can confirm things, because this is how the confusion lies in. And his response, which Mr. Holdwick does have a copy of it, was I won't answer it. I refuse to answer it. I won't view it, and I won't accept. So we get these issues where we get hung up and they don't know if he wants the kids, if it's gonna work with what he has going on, and we fall behind, or we get issues of things like this, and then I end up back in court.
Okay, can I have that counter back, please?
Because the reason why I declined them, Your Honor, is because the weekend that she put on there, basically that she's stating that it's her weekend and not my weekend, which is the opposite. It is my weekend, not hers.
Okay, so I just need to do this for my own edification. The first weekend of April is April 5, 6, and 7.
Mhm.
Who had the children?
Oh, gosh, Your Honor, I would. I couldn't even tell you. But I got it marked on my calendar at home, because I got an X on my Fridays that I have.
Ms. Hill, if you have any idea.
I have my calendar, a large calendar with everybody's stuff on it at home as well.
Okay.
But I did, Mr. Holbrook, do you have a copy of the schedules that I sent you in the conversation from? Okay, well, I sent the outflows calendar for June and July. I don't have a comment or acceptance on anything. He refused to open it, he refused to accept it, and he refused to apply.
All right, I need to know I need a history here. I need both calendars. Because it sounded like, according to the testimony, the weekend of May, the May date, that was quote unquote forfeited. My understanding appeared to be Mr. Polk's weekend. I can't forfeit something you don't have.
I even do have an app close for Miss Hill that stayed on here. Says, for the weekend of May 3rd, Kevin gave permission to forfeit his weekend and make up another weekend that was agreed by mother at a later time, no date or set time.
You want to show that to me?
Yes, I do.
I have a copy of that. Thank you very much. I also, he only printed out portions of the conversation. This went on for 2 weeks. He only printed out what he thought would be applicable for his parenting denial.
I find denied parenting time. It appears to the court that May 3rd was his date, May 17th was his weekend, and it looks like May 31st is his weekend as well.
So this coming weekend is my weekend, Your Honor?
Well, I'm based upon that clearly shows to me you can't forfeit a weekend that you don't have. So if it's alternate weekends, we can make the effective date May 3rd. May 3rd, May 17th, May 31. They alternate the weekends. And regarding make-up parenting time in the matter, if you don't within 6 months, parties have to agree to find a date.
I have a question, because I was led to believe through our conversations in my calendar that I had the children, there is no transportation set up. When I leave here, because both children got poison ivy at his house, I had to take my son to the walk-in because it was all over his cheeks before I had to leave to come to court today. So, and I can't go to his house because of a mutual restraining order. How do we propose that I get them there?
That's where you have to communicate somehow. It's a third party. I'm not sure how you communicate by app close, but
That's all I want to keep the same, what's going on. She can deliver this tax market from the Thermody Transit can bring them to my house.
If there is no busing set up, I cannot guarantee that that will be done by your court order time at 6 o'clock for our previous court date.
probably best to call right now to get it set up then.
And what if they can't while we're on the record?
Then you have to communicate with the other party to figure out how children get to you.
If they cannot, then I would prefer to meet somewhere locally, like the McDonald's parking lot or something. I do not and have not gone to his house before, and our mutual restraining order states that I am not able to, and he is not able to come to mine.
It just depends what time it is, because I do work the afternoon shift, Your Honor.
What time would you be available if you had to do a McDonald's trip?
Well, once I get home, I will be taking Quinn to the walk-in because he has whatever Lily had while she was there, came home with it on his face, and it's all the way across his cheeks this morning. So unless he would like to take him over the weekend, but he's just stated that he's going to be working.
I guess they.
Both of you have joint legal custody. You have to take care of the children.
Right, which it is I did this past weekend. My daughter went over to my brother-in-law and sister-in-law's house. She came back Sunday and had a rash and went to the doctor.
Bottom line, you have your parenting time this weekend.
Yep.
We have our starting date, and the makeup parenting time has to be done within 6 months. If the transportation cannot be arranged, both of you have to speak to each other to figure it out some way, somehow.
I'll be willing to take him, obviously, like I just stated, to the walk-in clinic, but I may not be able to be there by 6, and your judgment stated I had to. If you're going to allow it to be later, then I can arrange for him to pick up the kids at McDonald's, but I'm certain he just said he was going to be working tonight, so I'm not sure who's going to do that.
There's someone that can pick up the children if that can't be arranged.
Yeah.
Okay.
And another thing, Your Honor,
Who's back there saying yes?
if my mom or my sister.
Your mom or your sister?
Yes.
Okay.
Yes. And another thing, Your Honor, what is it, is I was
Do you
getting,
still have contact numbers for them?
I do no longer have any contact numbers. They were blocked in the past.
Provide the information.
and another thing, Your Honor, when I have the children with me for the weekend, Miss Hill needs to keep her nose clean about things and not worry about the children, worry about himself.
Mr. Code, I can't tell a mother to be not worrisome. I can't tell a father to be not worrisome. All I can tell you is you're both grown adults. You both have children you need to take care of, and that's how it goes.
Then my question before we leave while we're on the record, as far as the June and July schedules, I'd like to clarify that while we're right here in court, so I don't end up back here again.
Oh, it's very clear, because May 31st is his weekend, June 7th is yours, 14th is his, 21st is yours, 28th is his. That's how it goes.
And I would also ask Mr. Colt not forfeit weekends or not miss weekends, no matter what is going on, because it throws the schedule off and then we end up with these issues.
It's not before the court at this time. He needs to exercise his parenting time. If he doesn't, shame on him.
Yes.
That'll be all. Thank you. You may put your hands down. Mr. Lautner, you filed this motion for custody. What is the change in circumstance?
Change of circumstances is Mrs. Smalley, the mother, has been in the hospital since approximately Easter Sunday. And with the exception of every other weekend, which I'm still having the girls go to their grandmas, and some Wednesdays I have been in physical custody. And there's some struggles on the legal end, like I cannot get a DHS account because they're currently on a DHS account with her when she's not able to take care of them. So I wasn't gonna do this at first until DHS more or less told me without a report from her, this is my only option to get the legal things done.
So you have joint legal custody?
And physical, yes.
The joint legal, joint physical, okay. All right, and is this just a temporary thing?
Until the time she is home, capable of taking care of the children on her own, and a motion is filed with the court to go back to the original custody. Yes, that's what I'm asking for.
Request, okay. Ms. Smalley, what do you say about that?
The girls were going to my mom's house. Like, he hasn't had them this whole time. They were at my mom's like April 3rd through the 7th, then April 10th, 17, 19, 20, 21, and 24. And then May 1st through the 10th, the 24th, 25th, 26th. And then that was until noon, and then the 29th. So he hasn't had them the whole time. They have been with my family.
All right, but you would agree that, no disrespect to grandmas and grandpas, but parental rights are for parents first, correct?
Yes, I do agree with that.
Okay, and I don't want you to elaborate what the condition is. I'm just hoping and praying everything will be fine, but when do you think you'll be back on your feet?
My release date is June 5th,
Okay,
approximate.
Okay. All right, anything else you want to add?
I just wish that they could still be going back and forth. I don't know why he all of a sudden got this yanker and that they couldn't go see my family. It was when he says that they can go there, but whenever they can go to his family when they're with him.
When did, where are the children right now, sir?
At school, but they were picked up to go to would be her aunt and uncle's children's birthday party, and I'm picking them up at 7 from the party.
Have the children been with you?
Back and forth, yes. When she first went, I did continue the week on, week off until there were some issues. You know, sometimes homework didn't come back. One time a backpack, I'll send them to go with Karen, then I find out they're at Tara's, or even this week when they were supposed to go to Karen Wednesday, they spent 2 hours alone with the recent boyfriend before Karen was home from the city seeing Sam. The way I see it, those 2 hours, the children could have been with their father. She drives right by, you know, just little things like that. So it would be a lot easier for life until Sam was capable of taking care of them on her own. We made this change.
All right, well, the court does find a change in circumstance here. Clearly, mother is hospitalized right now, hopefully recuperating and getting back on her feet, being able to resume hopefully a normal life here in short form. But in the meantime, the children are kind of in limbo. Parties have joint legal, joint physical custody. And at this point, the court is going to grant the motion on an interim basis that physical custody will be with father until such time as mother files a motion to have the support, or I'm sorry, not the support, but to have custody re-reviewed so that when that time comes, if mother is fit, then the whole idea is to go back to the original order. So this is just a temporary stopgap measure. Now, we heard that possibly June 5th may be the out date, but what do we do about support in the meantime? What do you suggest, Ms. Schultz?
When children live full-time with a payer, it is appropriate to obtain child support. The court would only be able to go back as far as the date of filing, which was May 13th.
I'll abate support from May 13th forward until such time as the custody is readdressed when Ms. Foley's back on her feet. I will grant the motion.
Could I make one last request? I don't know if it falls in place with any of this or not, but when my time is being shared with the grandma and aunt and uncle, I would like a phone call if the decision is made to take them 2 hours north to the lake house, not just up and have it done.
Well, no, you have physical custody at this point.
Okay,
You've called shots here.
okay. But I've, you know, spoke my piece and things are happening without me being asked or notified, so.
Well, at this point in time, you have sole physical custody of these children on an interim basis. And when it comes to that, you can spell out exactly
Okay.
what they can and cannot do.
Okay,
Okay?
all right, that's all I was asking for today. Thank you,
That'll
sir.
conclude the proceedings and hope, Ms. Smalley, you get better.
Thank you,
Okay,
Judge.
I have something I'd like to say. When they are with him, though, they're with his sisters or they're with his niece or with, like, I found out Zoe was, or one of the children were with their friends for 2 days during school. So they're not with him. They're all over the place also.
Oh, they're with him now. He's in
Yeah,
charge.
she's speaking of a week I was training for the new job I took, so.
I understand, but on the
Okay.
flip side, when it's mom's time, they're with the
Right,
grandparents.
right,
So it's not
I-
both ways. And this is an FOC request for contempt regarding communication regarding Crystal Myers. The parties are present. Would you both please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth, so help you God?
Thank you. Please right in front of them.
Thank you, Your Honor. This is a show cause regarding communication and or legal custody issues. In front of the court, I have received complaints from Mr. Myers that there has been no communication or very limited communication by the defendant regarding the children and doctor's appointments or therapy appointments, payments on co-pays when it comes to doctor's appointments, things of that nature, as well as a complaint with communication that medication was not being sent with the children or given to plaintiff for the children unless there was money paid to defendant for a daddy-daughter dance as well as half of therapy costs. So this is a show cause regarding joint legal custody issues as well as the communication provisions.
Thank you. Mr. Myers, what do you claim is going on here?
Well, for starters, the therapy appointments and the doctor's appointments I wasn't being notified when they had therapy or when they had any doctor's appointments, which in the past couple of weeks, it has gotten better. And the girls, she went and cut the girls' hair. And when I say cut the girls' hair, I mean, it's up to their shoulders now. And I was not even notified that the kids wanted the haircut. And then the whole medicine issue, she told me I could pick up the medicine at 6:45 to 6:55-ish. I don't get out of work till 7:10 in the morning. So I asked her if she could just drive it to my house or to my workplace and just put it in my truck. She told me as long as I paid her the $82 I owed her, that she would. And we ended up working it out that I actually had to drive to meet her after I got out of work.
Did you pay her the $82?
No, I ended up paying for their next sessions of the full of the next session of therapy. And I still have not got her the $42 for the daddy-daughter dance. I have been trying to, but I got bills that keep on coming up.
We all have bills. So what, do you use Close?
Yes.
Are the therapy and doctor appointments put on the calendar?
She just started last month-ish.
And were you notified of the haircuts?
No, I was not notified at all of those haircuts. I found out the next day after they were done.
Okay. Here's your response.
The haircuts we had agreed upon back at around my oldest daughter's birthday in February, that comes springtime, that he didn't care that I cut their hair because both my girls wanted their hair cut short, so shoulder length. My oldest has been begging to do it. He agreed that that was fine. So when they begged me and my mother to do it, we said, well, you already agreed, that's fine, we'll just do it, you know, it ain't gonna matter. They were begging us, it's not like we forced them to. Doctor's appointments, he was being told, I just was not putting them in that calendar because
How did you tell them?
usually whenever we're on the phone.
I thought you were supposed to communicate by Close.
When he's on the phone with them, usually it's like, hey, we had this
On
appointment.
the phone with who?
When he's on the phone with the kids.
The kids are given the appointments?
No,
I don't
usually we discuss also, we talk back and forth on that too. Sometimes,
You and,
yes,
okay, but aren't you supposed to communicate by app close only?
yes, we do on FaceTime on there. He FaceTimes the kids on there.
Right.
And most of the time I tell him when the appointments are, I typically just don't put them in the calendar. I forget most of the time. I've been doing it. But it's also, I don't understand why I'm having to parent him to be a parent. I'm also finding things out, doing the stuff I'm supposed to. I go to the appointments. I have to set them up. No one's doing that for me. He's not showing up to any of these appointments. And even when I am putting them in the app, he still is not knowing about them or showing up.
Do you go week on, week off?
We are starting that June 5th.
Okay, during this time, you had the children majority of the time.
Yes,
And he'd have weekends.
yes. And I was
So why
still
would he
informing him
schedule
one.
appointments for the children for therapy when he only has weekends? Do they have therapy on weekends?
They could if it was set up that way, yes.
But it wasn't set up that way. It was set
No,
up during the week.
Yeah.
And you didn't let him know.
no, I do let him know. I just don't put them in the calendar just because it's not something I just, I got to do this real quick. Because normally whenever I schedule them, we get it scheduled and then I go home, get them dinner, get them bathed. And it's just not something I think to do right this minute.
Okay, so the other question I have is, he's claiming you held him hostage with this idea of the medicine only after he pays for the
No.
daughter date.
I asked him if he could pay me that money so I could use it towards gas to run it all the way over to him, as it was not my vehicle I was using. The medicine.
Wait, but your text message indicates if you have the $82 you owe me still for the daddy-daughter dance and you're half the therapy, then I will bring the meds to you at your work.
For gas, yes.
Doesn't say for gas.
That's what it was used for.
Doesn't say that though. I find you in contempt. Individual been held in contempt before. Check here out.
No, she hasn't.
Okay.
I don't believe she had. I believe we've had show cause with Mr. Myers.
Yes, that's who I'm thinking about. Okay. All right, I hold you in contempt for violation of court orders. I'm going to require that all therapy and doctor appointments be placed on the ACLOS calendar from this point forward. So there's no question. And then if he doesn't go, his problem. Number one, regarding the haircuts. At this point in time, I don't know if anyone agreed back in February or not. According to Mr. Myers, he's just knew of the haircuts after he discovered them. I didn't hear anything regarding February, but anything like that further, if there's any agreement between the two of you, it's going to have to be in the form of a writing. Because if there's no agreement in writing, it's not worth the paper it's written on. Regarding the medicine in this case, you can't hold hostage medications when, if one child requires medication, for instance, let's assume it's insulin. And dad has the weekend, the insulin goes with the child, period. The $82 or whatever it is for the daddy-daughter dance, whatever, you can't use that against him. You can bring that up in other venues to collect your money, but not when it comes to children's medications. With that understanding in mind, that is the sanction. No financial sanction will be imposed in this case, but you need to communicate. No more, you can, if you want to talk by phone, I guess that's your business, but I'm not going to accept phone agreements when you're ordered to have conversations via app close, because then we pull it right up. It's there, just like those text messages. We have an understanding.
Yes.
Sir, do we have an understanding? Anything from the front of the court?
Nothing further.
This is Ms. Martinez's motion regarding support and parenting time. All the parties are present. Would you both please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Here from the front of the court, please show us.
An order of support entered on February 28th of 2017. That order granted the parties joint legal and joint physical custody of C, with parenting time to be agreed upon by the parties, including alternate holidays pursuant to the 2016 part of the court parenting time guidelines.
And Ms. Martinez, what are you alleging here? What's going on?
We have not been doing weekend pickup for the past like 5 years since our son was 2. So we tried to do appointments together, doctor's appointments when it comes to our son. There's sometimes where he won't do them. And our son just recently got told by his dentist that he's gonna have to get braces. I made an appointment for a consultation and we already got told how much we have to pay him off. And I just want him to help pay half of it.
What about parenting time?
Parenting time kind of sucks right now.
What are you asking for?
Every other weekend.
And you're basing this on primarily the fact that for the past 5 years, father hasn't exercised his time pursuant to the week on, week off that's supposed to be occurring.
Right.
Supposed to be every weekend.
We have joint custody.
You have joint legal, joint physical.
Yeah.
But the parenting time is agreed upon by the parties. In other words, it's not court ordered that it's week on, week off.
No, this is something we agree to it, you know, there's other circumstances where, yeah, okay, I work a lot of hours. And she gets an attitude and throws a fit like a little kid. And just turns around and, well, you can't, when I want to get home, and she's like, well, you can't. You can't. And it's just to the point where we don't even get along. I can't even stand being in the same room with her.
That's unfortunate. Because
Unfortunately, yeah.
How many children do you have together?
One.
You gotta put that aside on behalf of that.
I know.
How old is he?
8.
8.
He's
Because
8.
C will pick up on that.
Oh, he's already seeing it.
Mr. Petrie, what do you want for parenting time?
Well, the thing of it is like summertime comes, I'll take them I'll take them all summer if she wanted me to. There's no big deal. I live in Saginaw, so I live with my fiance. So, you know, if I'm working and stuff, there's always somebody there for him when he's there.
What about, I'm assuming the child attends school here locally?
He attends USA.
Yeah, he's
So-
we're just trying to get so that.
So what are your thoughts of, so that we have this all spelled out? For instance, that, because it'd be difficult if you're living in Saginaw to bring the child to school in USA.
Oh, yeah, I tried a couple of times and yeah, it just is not.
Well, what are the thoughts of alternate weeks during the summer? And during the school year, alternate weekends, and any other time the parties may agree.
That's what we talked about before.
What do you think about that?
I like that idea. I talked to him about that before.
I live with it.
Okay.
And just the other thing about it is when she gets an attitude, she just needs to quit because she.
That goes without saying. I can address that in a minute. But do you believe that arrangement would be in the child C's best interest in this?
Yes, just because I just started working a new job yesterday, and that would help me a lot.
Okay. And do you think that would work best for C at this point? Because clearly you spend more time with you, and that is spelled out.
Yeah.
When exactly it is.
Yeah, I mean,
no
it's
issues.
just, like I said, it's just, you know, her and I just can't. I deal with her mom more than I deal with her.
I understand.
If we need a third party involved.
Here's how I'm looking at it. You have to have a united front for C, period. If you want to throw darts at each other, you want to buy a picture of the other and throw darts away from the child, go ahead and do it. But when it comes to both of you together, C needs to have a united front. So I find that in the best interest of the child, number one, that parenting time will be modified to alternate weeks during the summer months and during the school year, alternate weekends, typically what, Friday to Sunday?
Yes.
Sure.
Yeah, I can do the Friday night and Sunday. The problem is, she don't like it when I work Friday night. I'm a third shifter,
Oh, it's
so I
not.
work.
Well, I'm not gonna punish you for working third shift, because you.
No, I'm a third shifter, so I go paid Friday's my, Friday night is actually my Saturday. So when she gets her attitude, it's more or less, well, Cooper can't stay Friday night with your fiance because you gotta work and you don't wanna be there when you're not at home.
Mr. Petrie, did you ever see the movie Frozen? Have you ever seen it?
Unfortunately.
Yeah, probably countless
I was watching
times,
it
right?
with
What's the favorite song? What's the most popular song in that movie?
You're gonna ask me that? For real?
Yes,
For real?
I am.
Let it go?
Yes, let it go. Regarding the attitude, you just need to let it go. I know it's easier said than done. I get it, believe me, but for the best interest of C, I don't want the child to experience that. C is what, 8, you said?
Yes.
So, and it sounds like C is a bright young man.
Oh, he's smart.
Fridays to Sunday, normally it's 6 p.m. Is that okay, or should that be earlier or later, depending on your work?
Can it be like a little later? Like we say we can 8, like 7:30, 7:45 the latest
On Sunday?
on Sundays.
7:30 instead of 6 p.m.
Yeah.
And then Sunday at 7:30 as well.
Yeah.
Will that work?
Yeah.
Okay. And we're gonna get the baseline here in just a second. The week on, week off. When does school end?
School ends on the 12th of June.
What's the policy regarding that?
There's not a specific policy. The guidelines just state that summer break is week, which is already included in their parenting time order. So you have to look at what the weekend rotation is to determine who has that first week of school, unless the order specifies something.
So we should figure out which weekends. Okay, so presuming there's school, who would have the child this weekend?
He's supposed to have him this.
I'm supposed to have him this weekend.
And you still do?
Yes.
Let's use that as the baseline. That won't change,
Okay,
but it'll be 7:30.
yeah, that's fine.
That's what you wanted.
Yeah, that's fine, because sometimes he goes to work at night.
Yeah, because I got to pick up his brother and sister too.
They live here by that.
Alternate holidays.
If school releases on June 12th, the weekend of June 14th would be Mr. Petrie's normal weekend. So the week to week would start on Sunday, June 16th. So the parties can either start it that Friday and continue it for a 1-week period thereafter, with the child going back to Ms. Martinez on Sunday, June 23rd, or they could wait until June 16th, that Sunday.
But it would have been his weekend anyway.
It would have been his weekend anyway, so he's technically entitled to those 2 extra days.
So can you start your week on, week off beginning June 14th? We have a deal. Obviously, support will have to look at.
Correct.
But other than that, let's talk about the orthodontic bill.
Your Honor, before you go to ortho, can you clarify if the parties need a halfway point for?
Meeting.
Parenting time, please.
Where do you normally meet when you exchange?
He usually just comes to pick up.
Yeah, I just pick them up. I just pick them up and go.
Yeah.
Drop them off and go.
That works a lot. You just wait a minute.
He doesn't.
Yeah, I'm the only one that drives.
He does pick up and drop off?
Yeah, I'm the only one that's got a
There's
vehicle.
sometimes-
She can't drive.
There's sometimes though where I tell him, like if I'm somewhere else, like closer to him, he'll bring our son to me.
Sounds like he has a transportation.
Yeah.
See, you guys get better along as we talk here. Smile, Mr. Petrie, it's okay. What else? Other than the orthodontic?
Just ortho, please, Your Honor.
What's your position on the ortho bill?
We don't have an ortho bill.
Not yet, but I'd like to hear from Mr. Petrie what his thoughts are.
Is there a way that you said, when you get the bill done, she can pay half of her, just divide it in half, where she pays that half of it and I'll just pay the other half? Is that what, can we do it that way? So let's say the bill's like $3,000 and then I'll just pay my 15 part of my 15, yep. I'll pay like my part of the 1,500 and she could pay her part of the 1,500, just like split it right down the middle.
What about the uninsured medical.
Or they'll be treated separately
Yes,
if the
it can.
parties have an agreement. There is a form that the friend of the court has where you can both consent. We would recommend that if you're going to split it equally, you set up those payments directly with the provider, with the orthodontist.
Okay. Does that work for you?
Yes.
50/50.
Actually,
What, pardon me?
if he'll actually do it, I was hoping
He said he's doing it. He's up
Yeah, I
there.
got to. It's
Just
gonna
like
be
you are.
automatically taken out of my, whatever's left of my paycheck after you suck out the child support, but.
No.
think that only-
That's the cost of being a parent, sir. Believe me, if you were in a normal, I shouldn't say normal, but if you were in a situation where you just calculated you and your spouse living together, how much it costs, you think twice sometimes. If you were just thinking financially, but that's just how it is. 50/50. I think we've got a deal. Thank you both. You're both free to go. Show cause. Alleged denied parenting time. Will both parties please raise your right hand? Thank you. Who may I hear from the front of the court?
Your Honor, on April 5th of 2024, the parties appeared before the court, and the court had made a ruling with regard to Mr. Yarborough's attendance at doctor's appointments for the minor child. And while he was encouraged to attend, the court had addressed that if he was unable, that he would reimburse Ms. Murray for the cost of gasoline associated for those appointments, and that all appointments would be added to the app closed calendar no later than 3 days after receiving the appointment date from the treating physician. The friend of the court office then subsequently received a denied parenting time complaint from Mr. Yarborough on April 24th, alleging that his weekend parenting time had been violated for April 19th through the 21st. And we received an additional complaint that he was also denied his next scheduled weekend. That came in on April 26th. And it's my understanding, according to the written complaint, that it was denied because he did not obtain education with regard to these new diabetics. So the second weekend that was denied was the weekend of May 3rd through the 5th. But it is also alleged that he wasn't given notice of the appointment as well.
Was he given notice?
Through apples.
Oh. What about the April 19th through 21?
That was the first weekend denied, and then the weekend of May 3rd is the second weekend denied.
Okay. Mr. Yarborough, what do you have to add to this before I go to Ms. Murray?
Yeah, that's pretty much what happened is that I attempted to get our son from my time. She didn't come to the door, nothing. I knocked a couple times.
Is this with the Ring doorbell?
She has one, but I just regular knock.
Right, but I thought I read that.
Yeah.
Because the car wasn't in the driveway.
Yeah, because at first it wasn't. I pulled in, and then a few minutes later she showed up and asked me to pull out of her driveway so she pull in.
Right.
So then I drove around the block to come back in the apartment or to the house. I mean, and then try to get him. She said I couldn't get him because I didn't have the training for his pump. Well,
that was for April?
Yeah, for that first time in April. Yeah, that I got denied. Yes.
Okay. And what about May?
She said the same thing, but then she also told me that he didn't want to come with me either on the second time.
So did you receive notice of the pump training?
No, she, when you said that we had to schedule that in the calendar, I never received any notice, or because I think we have to be shared, I think, in the app close for us to receive any notice. And I not got any notification of that at all.
Ms. Murray, your response.
Well, that's a lie, because I have text messages in app close where I kept asking him, are you coming to the appointment? He told me no, he had another appointment with his other child, which I found out that was a lie. And he could have called down there.
This is an app close that you were.
Yes. Yep. I kept asking him multiple times, even on the way down to the doctor's office, if he was coming. He told me no.
Did you put it in the calendar as quarter?
And I put it in the calendar, but I put it in wrong when I talked to Mitch. She said that I didn't put it in the right.
Mr. Holdwood, she's
Mr. Holdwood. When I put it, I didn't put it in the right way.
So where are these messages saying that?
I have them on. the app closed, but when I called and talked to Mitch, he said I didn't, yes, sorry. So, when I called and talked to him, he said I didn't put the date for the appointment in the correct way on the app post.
What would give you comment?
I've been seeing lately parties when trying to put appointments in the calendar, they put it in the calendar on their own end, so they see it on the calendar. But there's a portion when scheduling that states share with other parent, and that gets missed a lot. And once it's actually properly shared with the other parent, one, it's shared on their calendar, and two, in the app closed text messaging, it states event shared with parent and actually has what the event is. So it's kind of covered both ways to show that it's been shared properly. So if she did share it, or if she thought she shared it, put it in her calendar, it would have been put in wrong where Mr. Yarbrough would not receive it in the app closed.
So how do you respond to Ms. Murray allegedly texting you saying,
Well, she did ask me if I was coming to his appointment when he was getting on his new pump. However, I had that same day, the first session with my other son with his therapist.
okay, so how many days notice did you get?
I think it was that same week, I believe it was, or that day, I think it was. I knew about it. I can't remember the exact amount of time, but I think it was within that week.
And when was that?
That was on the appointment that he got his first pump was that Friday, the 19th, I think it was.
April?
I believe, yes. And I think it's either that day before, yeah, because she asked me for gas money that day before for the $30, and I gave it to her. I sent her through through Cash App. I sent it to her, and then I told her, no, that's when I had my first session with my other son with the therapist. So I couldn't.
So you do acknowledge notice then of one time?
That part, yes.
Okay. What about May 3rd and 5, May 3, 4, 5?
That was just me attempting to get my child, and she denied me, and I did all the things I was supposed to do to get him.
Okay. When's your pump training scheduled?
There's nothing scheduled. I got in the last 2 weekends. She's let me have the last 2 weekends for my holiday and the time before that, and everything was fine.
When are you going to the pump training?
I didn't know there was anything scheduled. I don't know I had to because I got word from her. I didn't honestly think I needed it because of all of his previous.
Don't you think it'd be important to go to the pump training?
Yes.
Why don't you call Dr. Degnon's office and set it up?
Well, I don't have his new number since she didn't tell me that there was a new location when I didn't find out. Every time something changes, she doesn't tell me right away.
What's his new number?
He can call 23 miles, and Bridget will just do everything that way. It goes right into his file that is shared between both locations.
Yeah, I didn't know this at the time. She doesn't tell me stuff right away.
Well, it's bad when we have to do it in court at 12:35 in the afternoon.
Yes, it is.
So, okay, this is what I'm going to require. Number one, before I make my ruling. Ms. Murray, you're required to give the phone number again to the 23 Mile Road office of Dr. Bernard Degnon, so he can schedule his appointment. The pump training is very important. Regarding April 19th through 21, the court finds there's no contempt here. There was some notice provided. Now, it wasn't in the calendar as it's supposed to be, but father did have knowledge of it. But May 3 through 5 is denied parenting time. I find mother in contempt, and the result here is very simple. 1 weekend of makeup time to be scheduled between the parties within the next 6 months. Any questions?
No.
Sir.
I do, but it's kind of about parenting time, but not the specific ones. With the summer parenting time, because we had some issues discussing this. Does the summer parenting time start as soon as school gets out or when summer actually officially starts? Because the weekends and then to summertime, how does that, I know we've had issues with that in the past.
Let me turn it over to the front of the court on that question.
One moment, I have to find their summer order.
Because we have the old guidelines from Canal Block.
You're still doing your alternate weekends and then the two-week periods under the 97 guidelines, correct?
Yes, that's correct.
So the 97 friend of the court parenting time guidelines, and I apologize, Your Honor, that I'm not seeing them.
No, you're fine. So I'm trying to figure it out here myself.
So under the 1997 parenting time guidelines, I did not receive a notice of selected dates by May 1st. Were dates exchanged between the parties? Okay. Then under the guidelines, it would be the default period of the second Friday in July, starting at 6 o'clock and ending 2 weeks later, Friday at 6 o'clock. And then again, the second Friday of August and ending 2 weeks later on Friday. Alternate weekends would continue except for during those 14-day periods.
So up until July, I have my weekend visits, right?
Correct.
Okay,
Answer your question?
that's very much.
Any questions? This is a show cause hearing. Allegations of denied parenting time on behalf of mother. Both parties are present. Ms. Griffith is in the courtroom. Defendant is via Zoom. Would you both please raise your right hands?
Yes.
Okay, thank you. Be here for the front of the court.
Your Honor, on January 19th of 2024, there was an order entered regarding the minor child AMH that gave the parties joint legal and joint physical of said child with week-to-week parenting time of the child. We have received a denied parenting time complaint from Mr. Hernado stating that he was denied parenting time for the week of May 13th of 2024. In his allegation was that the child has not been doing her schoolwork while with mother for the 2 weeks that she was with mother, and was in danger of being removed from her school academy that she was participating online. Since the notice was sent out, Ms. Grifka has contacted our office stating that she believes it's not safe for the child to go back to Mr. Hernado's home due to an incident that involved Mr. Hernado being hospitalized. And these were involved, but that is the current status, Your Honor, and I'll defer to the parties.
Okay, thank you. Mr. Hernado Lopez, why do you believe that your parenting time was denied?
Well, she left on the 3rd, and even before she left, I was thinking, well, Mother's Day is going to be that following weekend, so I wouldn't care if, I wasn't even going to bring it up. If she would have kept her to that day, that's fine. She would have kept her to that day. But then time went by and still she didn't come back. Then it's like she's telling me that she's giving her, like she don't want to come back. But I remember when we first went over there that I brought up the fact that she even had told me before that she didn't want to go that amount of time over there, that I was supposed to enforce it. So I'm pretty sure that mom should have been able to do the same thing. And even if she had whatever reason she had, if she wanted to keep her, there's also legal channels that she would have been able to like submit paperwork or do any kind of legal action of having her back home or stopping her from being here or anything like that. Not just, well, I'm going to keep her and then what, like nothing has been done. So
it's supposed to be week to week, correct?
That's correct, Your Honor.
Okay. I heard something about something at the home that you were hospitalized for. Can you explain that a little bit?
Yes, I had a reaction about a little mistake that I committed while there was no kids in my home, absolutely no kids in my home. And on Sunday, after that was on Saturday, then on Sunday when I had the reaction, well, it definitely I learned my lesson on that one because I got very scared about even my health and everything. And then I took action over it. I went to the hospital. I stayed the night. I wasn't forced to stay. I decided to stay. And Monday morning, I did everything that I was supposed to do. I decided to enroll myself in some counseling that will help me deal with depression and how I dealt with it, because part of it is every weekend, my daughter would tell me, not every weekend, but every weekend she had to go. On that Friday, my daughter would tell me, talk to mom. I don't want to go. I don't want to go for that many amount of days. or see if she can come get me the following day or 2 days after. And it's making me feel.
Sir, we can't go into what the child had said. I'm just looking as to what the issues were. When the child, obviously it's week on, week off, during your week, is the child going to school?
Yes, she was going to school on her laptop with no problem. I will make sure every day I will go to her and be like, hey, don't forget to do your schooling. Since she's got the option of what time of the day she does it, doesn't affect her with anything. So, and no problem. Then I received an email from the school for those first 2 weeks that she was from the 3rd till the 17th. On the 16th, I received an email from the school that she hasn't been doing her schooling.
So on your time though, was it all virtual schooling at home?
Yes, Your Honor. Okay. It's always virtual.
It's always been virtual. Okay. Okay, I think I've heard enough for now. Miss, what's your response to this?
As to what?
As to why you're not allegedly following the custodial time.
So Ava actually, or I'm sorry, Ava was supposed to go back to her father's house the day after Mother's Day. And I didn't hear from him until the 17th. I didn't know what was going on. From the police report that I received, he was under the influence. There were children in his home. He was hallucinating to the point that they thought he was going to die. And I did not want to return her to that situation. She does not want to return to that situation. And I'm just asking the courts to acknowledge the fact that we are in this situation because I was supporting what my daughter wanted to do. I've had sole physical and legal custody since we've been divorced in 2012 of all of our children, even our 8-year-old that he doesn't file anything
I thought you had
for.
joint legal, joint physical.
With one child, yeah.
Right, this one.
Yep. We have other children.
I get that. But
And I just want the courts to acknowledge the fact that I've had sole physical and legal custody since our divorce, and that's the way hopefully it'll be returning.
well, there are allegations that the child is not getting homework done.
Oh, she is. I mean, today was her last day. Yesterday was her last day of school. She's not going to return to the Sale Academy next year. She wants to go to the Ascent School.
So I'm assuming with joint legal, you talked to Mr. Ornado Lopez about that.
I haven't heard from him since the 17th, sir. And before that, it was the 7th.
Right, but you can't make unilateral decisions like that without having the father involved.
He's the one that enrolled her into the Sale Academy without my knowledge, so.
Well, 2 wrongs don't make a right, but that's not what we're here for today. So. Did you request to have the child returned?
Your Honor.
Oh, wait, just a moment. Mr. Holdwick.
If I can kind of add on what the parties have been stating in reference with the police report that Ms. Kripke had referenced. It's our understanding that the reaction Mr. Hernando Lopez is referring to is substance of methamphetamine. And to our understanding that there were 2 other minor children in the home that he does have.
Well, here's what I'm concerned about. That's one thing. That's clearly one thing, but here's the other part. There are allegations that the child is not getting the homework done. Now, mom says they are being done. Homework is being done, or she's attending. But I had father saying he's getting emails from the school saying it's not being done. Is there a DHHS investigation at this point? You know?
I'm not aware that it's been referred for information from the friend of the court office, nor am I aware of any filings for any file.
Sir, in the police report, they said that they contacted, there's a suspected child abuse and neglect sheet. Not sure what that pertains to.
Okay.
I'm just asking that if there's an investigation, she's just not going to return until it's over.
Well, this is concerning to me on both fronts. The allegations regarding father and the allegations that the child is not getting an education. Court is going to do two things. Number one, court is going to, on its own initiative, appoint a guardian ad litem on behalf of the minor child, so the child has a voice. Number two, regarding contempt of denied parenting time at this point, based upon the allegations, contempt is dismissed. What we do in the interim at this point, I'm not exactly sure, because I'm concerned very concerned for this child, because it's reported on one end that she wants to be with father, and on the other end, she wants to be just with mother. But the GAL will be important there.
She did want to be with her father, but she's scared. If he can maybe submit to drug test.
Mr. Ornado Lopez, Ms. Griffith, sounds like she's offering that if you submit to drug screens, random drug screens, we could figure out what we want to do in the interim while this thing is moving. What do you think about that?
Your Honor, if you were to contact Nathan Lick, he can tell you that I have already submitted 2 tests and that I'm currently going through counseling and that everything has been the way it should be.
So you're still on probation to this court?
That's correct, Your Honor.
How often do you test?
Twice a month.
Do you have employment?
I have an appointment on Tuesday.
Do you have any income?
Yes, Your Honor. I have a full-time job with Gemini Plastics.
Okay, so you have employment right now?
Yes, that's correct, Your Honor. The same employment that I've had the entire time.
Okay, I just want to be sure. If I order random drug screens.
That would make me more helpful.
And Ms. Schultz, what do you propose on that?
If Mr. Hornado is already testing and it is a random schedule for DOC, if that's through a chance to change, he can just sign a release to have those records forwarded to the front of the court office.
Right, but 2 times a month. I'm a little concerned about that. Let's do this. I'm going to order on an interim basis for the next at least 30 days, if not 60. 30 days, random testing with chance to change for father at a minimum of 2 random tests per week, on top of what he may be receiving through the Department of Corrections. That will be, again, 2 times per week at a minimum. You are to sign a release, Mr. Ornado Lopez, so that the front of the court can get that information. And if the tests show negative, Mom, you're okay with the week on, week off?
Of course.
How about that?
That's fine with me because I have nothing to hide, but it's also not that easy for me to be able to pay for everything and on top of that pay for a chance to change, Your Honor.
I understand that, but that's the cost of doing business at this time. I mean no disrespect to you or to mother. I'm looking out for the safety of the child. That's all I'm concerned about. So it'd be your responsibility for the payment. Anything else?
Is the court specifying a guardian ad litem, and are the parties responsible for the cost?
Are you employed, Ms. Griffith?
No, sir.
I just want 1 visit with the GAO. Let's just get 1 visit and the court will take the expense.
And is there a specific attorney you would like to manage, Your Honor?
How about Dallas Root? Dallas Root. Then the child is an independent voice and we can put all that together. I'll order the test immediately As soon as we get the first test and it's negative, can we start right after that?
Yes, sir.
Sir, can we start back right after that, the week on, week off?
That's great. I haven't been able to see her since the 3rd. And I know I have contacted mom. I have talked to my daughter multiple times. Then mom even contacted me. She likes to send me screenshots of things. So it's not that she didn't hear from me. She have heard from me. She have contacted me from that point.
When is the normal week on, week off schedule? Whose week should it be right now?
Honestly, I forgot, but so she should have gone back the day after Mother's Day. So that Friday, the day before Mother's Day, she would have been going back, but I kept her until Mother's Day.
The parties exchange on Fridays, Your Honor, and looking at that with Mother's Day, the week of Mother's Day would have been Mr. Fernando Lopez's, so actually this Friday would technically start Miss Grifka's week.
Oh, be Miss Grifka's week?
Yeah, this past week would have been Mr. Fernando Lopez's.
Okay, so this week, this Friday would be Mom's.
Correct.
Okay.
Correct.
So we June 7th.
I'm sorry?
We resume Dad's time on June 7th.
And that's if the test clean?
Right, yes, negative.
Is the court giving the friend of the court permission to share that initial test result? Or would it be a matter of you want an ex-party order entered to resuspend parenting time if we had a positive test?
Let's do it the second way. Just to preserve.
It's presumed to be a negative test unless an ex-party order.
Right. So it'll be presumed to be negative. But if the friend of the court gets something that's otherwise, I'll sign an ex parte order suspending the time.
Okay, and then you guys will contact.
Notification will be provided.
Thank you.
Let's start that way. That's how we'll proceed. Anything else?
No, yeah, I think.
Go ahead, Mr. Fernando Lopez.
Oh, Your Honor.
Did you have anything else?
So what about the weeks that she's been gone?
At this point, I'm denying the contempt based upon there was a valid reason, just cause to deny the parenting time. As soon as I heard methamphetamine, that's very concerning to me. So she's justified. I don't, we don't like to take the law into our own hands, but I'm looking out for the best interest of the child. So we're going to move forward. Now we have a clean slate.
So in other words, once I do my testing on Tuesday with Mr. Lick, she can come here, or whether it's with a chance to change, or because it really doesn't matter to me. I have nothing to hide.
No, I understand that. But technically, today would be the start of Mom's week. So Mom would have the child from May 31st through up until June 7th. Then that would be your time. So that's when yours would start. But not only the DOC, but I'm requiring 2 tests the week of June 3 through 8, or 2 through 8, from you through chance to change.
I'm not sure how the test on Tuesday that he's referencing Mr. Lick is conducted, if it's in DOC's office or if it's at chance to change. But the first negative chance for change result would start the parent.
Correct.
Just for clarification.
Yes, sure. Just so that we're clear, because I want the independent testing. Any questions, sir?
So who do I contact to, should I just go myself to chance to change tomorrow or on Monday?
Yeah, you could go to their website, or if you contact Mr. Lick has that contact information too.
Your Honor.
Okay.
Friend of the office will send a referral, so Mr. Tornado only needs to contact the change and let them know that it's on its way.
Oh, FOC is going to cover it, sir. They're going to send a referral over to Chance to Change. And then once that referral is sent, I'm assuming they're going to send it today. If possible, they'll try to send it today. Call them first day next week, and they should have the information ready for you to test.
All right, sounds good.
The whole truth, nothing but the truth, so help you God.
Yes, I do.
Yes, I do. Okay. Thank you for the front of the court.
So yes, Your Honor, currently, Mr. Durbin has alternating weekends with reminders of AJE. We have received a denied parent time complaint for the weekends of February 16th to February 18th with HAD, as well as March 1st to March 3rd with HAD. Notices were sent, 21-day alleged denial was sent to Ms. Howard for the February dates on February 27th and for the March dates on March 4th. Ms. Howard did respond timely to those complaints, stating that the minor child HAD had an in-camera meeting with the court, in front of the court, back in December of 2022, that the minor child is not wanting to go to Mr. Howard's or Mr. Durbin's, that alleged Mr. Durbin has told the minor child not to come to parenting time, that there's been physical altercations in the past, and that the minor child has not had parenting time, or that Mr. Durbin has not exercised his parenting time in over a year and a half with the minor child, since December when the in-camera interview had happened. So it was set for notice of hearing, Your Honor. We have not received denied parenting time complaints since then, and we didn't receive them before. So the notice of hearing for alleged denied parenting time was set for today, due to the allegations of denied parenting time, as well as that parenting time hasn't exercised in over a year.
Who's objecting?
There's no objection, Your Honor. Her response came in timely to the denied parenting time complaints, and her response was he doesn't want to go. Dad's told him he's not coming, as well as Dad hasn't had parenting time in over a year and a half since December of 2022.
So what's the question?
It's for judicial determination if the denial is valid or not, given that he allegedly has not had seen the child in over a year.
Okay, that makes sense. Okay. Before I go to Dad, Mom, what is the story regarding the parenting time over this time frame?
The child does not want to go to his father's due to altercations between the two of them. They do speak occasionally through messenger. Their father likes to message him while he's at school and stuff like that. Sometimes he responds, sometimes he doesn't. Currently, in May, their great grandfather died. They did see their father at the memorial. My daughter's birthday party was on a day that they had a softball game. So I did invite Robert to come. I did not tell my children, the older two children, that their father was coming. So he did get to see his two children. They didn't engage with their father, but they were still there. At the memorial, they did engage a little bit. I do my part that I'm supposed to encourage my children to go, but they do not want to go. Well, the said child. The other one just graduated, so his should be done.
But what I'm wondering about is there was a statement by Mr. Holbeck that the child hasn't been seen in over a year.
Since that child spoke with you in your quarters, that was the last time that.
In December of 22.
Yep. He refuses to go, and I can't physically put him in a car and make him go.
It's one thing about refusing to go, but did Dad request the time?
Yes. He was asked. He was asked on he said, because we can only put about pick up and drop off. Like he'll be there at 6 to pick up kid A and kid A, because it's both A's. But the oldest does not go.
I get that, but maybe you'll understand my question. Is Dad requesting the parenting time of HAD?
Yes.
Every time?
Not every time, no. Just whenever he feels like it, he will say something about it, or, occasionally he'll throw in something here with the court and we'll have to come in front of you.
How old's HAD?
17, gonna be 18 in March. He has 3 credits left for high school next year. He'll be done in November.
Okay. Mr. Durbin, your response.
When the last time we were with you guys, we were told to do the high risk co-parenting classes, and in those classes it says not to alienate the other parent and stuff, and that's exactly what's going on. And she said she can't legally coerce Alex into going to my house, but that would entail she would have to actually try to get him, like, have a normal conversation, like, and treat me like a normal human being. And I haven't seen my son, and I haven't, and every time I do petition, I usually get in more trouble. So I'm really terrified of the courts, because I just want to have my kids, but I get bullied out of the courtroom usually. And I just, we're supposed to follow the rules, and I'm the only one that has to, or you know what I mean?
Well, so how did sorry to hear the passing of a family member, but how did the meet go when you saw your son?
I talk to Alex. I message him all the time, and everything's
No, I'm talking about the
it was calm and normal.
Okay. Did Did you get the sense, I'm not asking what the child said, but did you get the sense that your son didn't want to be around you?
No.
The February dates that we talked about.
I'm sorry, Your Honor. And if I, you know, if I made a complaint every time he didn't show up, I would be tied up with you guys a lot, and I have to go to work, you know, and just like today, I was hoping that, you know, she could do the show cause for not letting or not having Alex come with me, but I was told I had to appear, and that's why I'm on Zoom today. But if I'd be spending a lot of time making complaints so people could explain why I shouldn't have my son.
Okay, so you said you do communicate with HAD, whether texting or Zoom or FaceTime, anything like that?
Just Facebook Messenger.
Facebook Messenger?
Yeah, just chats here and there, just to tell him I love him and tell him I'm thinking of him.
Does he respond?
Sometimes.
Have you ever posed a question to him, would you like to go fishing?
Yeah.
You've done that?
Yeah.
When was the last time you did that? As an example.
A couple of weeks ago, or just, I think maybe it was last week, I told him that we should go fishing or go disc golfing.
Did he have any response?
No.
And he's 17. That's the issue too.
Sure. And he lets me know when his father messages
Well,
and everything.
he's been,
And I tried
before he moved out, he started going back to his mom's, and he started bringing home like weed paraphernalia and stuff, and I didn't like it, and I told him he couldn't go to his friends anymore. And that weekend he snuck out of the house. His mom picked him up, and he said he'd never talk to me again because I wouldn't let him go hang out at a friend's house. And that was I said no, and now I haven't talked to him for 2 years.
Okay.
That's also a lie, Your Honor.
No, it is not.
We don't need to go back and forth here. So when's the last time, sir, other than the funeral, that you've seen the child?
Addison's birthday.
When's that?
Sorry, my daughter's birthday. It was about a month before that.
That was May 9th. And May 18th, you see them.
Just a moment, because I'm asking him, I'm not asking you. Do you have a date, sir, when the last time you've seen the child other than the child?
I can look on app close real quick to figure out the exact date.
Okay.
Yeah, it was May 7th.
Okay. Anything else before I go back to Ms. Howard?
I filed the motion just so we could get, you know, just so I could figure out when I can get parenting time again with my son. It wasn't anything like he said, she said, like drama stuff. Everything's been really calm, even between me and Miss Howard. And the whole thing is,
when would be your alternate weekend? Would it be this weekend?
It'd be next weekend.
Okay. Next weekend.
That's all.
My turn?
Yes.
Okay, he did see these children on May 9th. I did not let my boys know that their dad was coming on purpose, so that way he could see his children, because otherwise they would not have came. And he did get to see his children. They sat in the car, and at the end of the game, we sang happy birthday with a cake with him, his girlfriend, his mother, his grandmother, me.
I'm sorry, Your Honor, is this relevant?
Other two children, so he did get to see his
It is
children.
relevant to figure out what we need to do here moving forward.
He did get to see his children. Before his grandfather died, we went to his grandmother's, the alleged child right now.
I need to cut to the chase here, Ms. Howard. What do you do to encourage a positive relationship between dad and son?
Everything I can. Basically, I try to get them to go with their dad. I have no issues with the other children. The other one is 18. He hasn't been to his dad in 3 years. They had physical education. There is a police report with Stanley County. That's the only reason that this even started.
You're not answering my question, Ms. Howard. What do you do to encourage a positive relationship?
I tell him he only has one dad, and you can't take that back. Take away that.
If your son hypothetically says, well, I just don't want to see dad, what do you say in response?
I said, you only have one dad. You won't have him forever. I lost my dad, so it's important for me, for my kids to see their father and to see their mother both.
Okay, it's one thing to say you have one dad, but what are you doing to encourage him to go see?
I try to get him to go, but he refuses to go.
How do you encourage him?
I tell him you have to go to your dad's this weekend, and he refuses to go.
Have you ever said, I want you to go to your dad's
Yes.
this weekend?
Yes, and I basically the one time that him and the other oldest child went, it was a total disaster.
Would it be best if I meet with the child again?
Yes.
Sir, what do you think about that?
Why don't you meet with my daughter to see how things really are instead of trying to alienate me further?
Why would the court try to alienate your son from you?
Because he's mad at me and he says whatever he can to get out of doing whatever he wants.
Well, if it's not worth it, it's not worth it. But Dad's entitled to parenting time. There's no question about that. There has to be a showing that mom is trying to circumvent this. The problem is when you have a 17-year-old who's under, the court order applies to the parents, it doesn't apply to the child. I can't court order that son has to go to dad's house. In other words, and if son fails to do so, son can be held in contempt. The only other way around that is to file a delinquency petition that the son is not following the reasonable rules at home, which is a wholly different matter. So regarding the parenting time, at this point, it is to continue. Regarding the denied parenting time that's been involved in this case, it sounds like there's animus between Mr. Durbin and the child relative to dad being a dad and trying to discipline the child, which is understandable for dad trying to discipline. But when you have a 17-year-old who appears to be very headstrong, you're only limited as to what you can do. I will require mom to not only strongly encourage, but strongly encourage this for the parenting time.
Sorry.
Well, what was that, sir?
Or maybe ground him if he doesn't. Like give him another option, not say, oh, you can't, you're not going, or you have to go, and then nothing else.
Well, the parties have joint legal custody, so they have equal decision-making power. Mom, what do you say about that?
He has had that ultimatum, and it doesn't matter. He doesn't care. He'd rather have everything taken away. He does not want to go. There's physical altercations.
So be it.
And that I don't physically try to force the child in a car is for one. He's 17 years old, and I can't do that. Two, because why am I going to put a child in a situation where there could be further altercations?
I will require mom to encourage and strongly encourage, and I don't care if you videotape it. Have video coverage of it, and then if it comes back, we can, because I'm not seeing anything from mom other than maybe a disagreement between mom and dad is if you don't do something, then you're going to get disciplined for it. Ms. Howard saying she did do that, and that didn't even work. So I can't find mom did something to thwart the parenting time. I don't have jurisdiction over the young man.
And I apologize because I have been trying.
But I'm going to force you to try even harder. And if you fail to do so and it can be shown, then you can be held in contempt. There's nothing else I can do.
So should I videotape on Fridays when he's supposed to go?
I think that'd be a wise idea. I think that'd be a wise idea. Maybe it puts son on notice and say, look, now a judge is going to see this.
Could we do another where he comes in and speaks to you personally? Of what the real issue is, so it's not between me and the father. You
only if dad agrees
to this child.
Only if dad agrees. He doesn't agree. Do the videotaping. That's all we can do.
Okay.
Show cause dismissed. I can't force the child.
Thank you, Your Honor. The parties have joint legal custody with plaintiff having physical custody pursuant to parenting time order from August 5th, 2022. The parties have, or Mr. McLean has alternate weekends from Friday to Sunday at times mutually agreed between the parties. So there's no set times for the exchanges, just as they agree. We were last before the court for a show cause regarding communication back in October 2022, in which Mr. McLean was found in contempt and sanctioned the $250 fine. The show cause that was brought forward on a complaint from Mr. McLean is that for the weekend of April 26th to April 29th, he's been denied his parenting time. My understanding is there's issues with the child's sports, and if he is getting his parenting time on this weekend, it's not on Friday, it's either super late Friday or it's the next day on Saturday due to the sports. But the show cause kind of also ties into, I believe, Ms. Anker's parenting time motion today as well.
Okay, so as I understand it, the parenting time it's not concrete, or is it always alternate?
It's alternate weekends. It was a phased schedule, and the last phase is that Mr. McLean would have alternate weekends from Friday to Sunday at times mutually agreed by the parties. There was no set times.
No set time, but at least it's supposed to occur. Correct. I see. Okay.
And part of it as well, from responses that we've received from Ms. Anker, is that there's there's hardly communication regarding a time or discussion regarding a time for Friday to Sunday. That is Mr. McLean saying, this is when I'm getting, this is the time I'm getting. She says I never agreed to that. Argument ensues, and then If he has to get his parenting time, it's later than Friday or, sometime on Saturday.
And the show cause regarding contempt is the communication issue.
No, that was the last time we were here. I actually believe this was a notice of denied parenting time for the weekend of April 26th to 28th.
Okay, because the document said.
Yes, I know the docket says show cause, but I was looking at the file, Your Honor, that we had filed. There was a notice of hearing for denied parenting time scheduled for today for that weekend.
So that's what we're here for.
No, Ms. Anger also has a parenting time motion.
Right.
Yeah, right.
Ms. Anger, what's going on here?
So I did not deny him time that weekend. He refused to set a time with me. I have other kids. We've never had a set time because of his work or whether he's had a vehicle. It's not just on my end, it goes on both ends. Especially when he used to get his other son, like we've always worked on time together, but once in a while he gets in the stiff that if I don't do what he says, then I'm going against the court. And I'm like, no, 5 o'clock did not work for me that day. He refused to get a hold of me. He said on that Wednesday, he's like, nope, you are at 5 o'clock. If you're not there at 5, you'll get it. You'll be in contempt. You'll do this. I'm like, 5 o'clock don't work for me. I have my other kids. They have practices. That does not work. He refused to work with me on that time. And then he didn't get a hold of me the rest of the weekend. It is not my job to get a hold of him continuously and go, well, when are we meeting? When are we doing this? When are we doing that? When are we doing that? I've even been told by this court at times that it is not my job to make sure he's a dad.
So what's his business with birthday?
He already had his phone call. He gets one phone call and we do it through Zoom a week. He already had that on Wednesday, which the Wednesday at whatever time is convenient for him. He already had it on that Wednesday, and any other, the phone call during the week is whatever time works for us, whatever day, whatever time, because we both work, we both have schedules. It's on Wednesdays because that's what works. So he did have that. He asked if he could talk to him on that Saturday on his birthday. I said yes, but I was at my oldest JV softball game and we had a birthday party. So as soon as we got home, we had extra kids, we had other adults there. My husband was there and ended up talking to Chris himself because I was not dealing with that. As soon as he got on the phone, you could tell he was under the influence. There was, we can set another date and I can have witnesses. There was other adults there that were like, was he drinking? Because he was slurring his words. He was irritated right away because I wouldn't do the Zoom call as soon as he wanted me to. I told him I would get a hold of him. I wasn't lying, we were busy. We had multiple children there and multiple people. We were doing a birthday party. Z did want to talk to him, but as soon as I realized he was under the influence on the phone with the slurring and that right away, no, I'm not subjecting an 8-year-old to talking to somebody while they're under the influence. I don't care who they are. So, and it was constant physical, it turned into physical threats towards me and my husband. And this is, we've been, like he said, we've been in here before, in 2022, this has been going on for 8 years. It doesn't stop. So I guess I'm going to have to call the cops every single time it happens. But I had police officer at my house twice during a birthday party. He really had to do that during an 8-year-old's birthday party.
So what are you proposing regarding parenting time?
The drinking has got to stop. There needs to be something that he is, I have a child with him. I was with this man. I do know him. The drinking, he doesn't see it as an issue.
Right, but didn't you state that you want to just have one day?
If he can't, I don't take his time. He has offered, okay, if he has that game, he moved closer in the parenting app. He stated himself, he moved closer to be at school functions, to be at sports. He's been to 2 football games last year.
But you didn't answer my question. Because it's Friday, these aren't overnight, are they? They are overnight.
They turned to overnight.
The motion said that you just wanted to have one day.
Yeah, he needs to just have one day. If he can't, how can I make sure my son is safe if he can't even call him on his birthday without drinking at 3 o'clock in the afternoon?
And that's what the show cause is for. Because the show cause that I have here is against Mr. McLean and dated by you, Mr. Holwick, on May 9th. And then the email you received from Ms. Hanger. And then the conversations are attached afterward. That's what I saw.
Yes, that's what I sent in first.
It was noticed for the issue of parenting time. It was not, consent was not requested based on the notice that we have.
I got,
That's not what my file shows.
I got 3 different ones at home.
Are you aware of this?
Yeah, that looks familiar, yes.
Okay, so we have the show cause for the notice of hearing, alleged denied parenting time for weekend of May 26th to May 29th, and issues regarding the minor sports. Who is to have the child between May 26th and 29th?
May 26th and 29th, that's during the week.
Yeah, this doesn't make any sense. It says alleged night parenting time for the weekend of May 26, 2024 to May 29, 2024.
Yeah, that should have been April. That was a typo on my end.
Oh.
Yes, I caught that this morning.
Oh, now I see.
But the show cause though, Your Honor, I don't have the responses, but that's not.
Okay. Okay, so now I've got it. And father was supposed to have a child on April 26th to the 29th.
Yes, I haven't seen him since the beginning of March.
Okay. What's going on?
Well, I asked her, I don't have a problem with sports, but choose one or the other, hockey or football, because each sport is about 3 months long. Well, if he's in both, you're taking 3 weekends out of me. All right? So from Friday until Sunday, I'm supposed to get him every other weekend. Well, I compromised with her and told her, I said, one sport or the other. I'll come out and see him. So I did with the hockey. Well, he got done with the hockey. Well, then she put him in football. Well, since January, I've been arguing with her about that. They're taking my weekends again. Well, she doesn't care. Then she told me through AFCOS that she didn't have to listen to that because the child lives with her. The courts told her that. This is why this has all been going.
You understand the parties can't agree regarding extracurriculars in general. That is joint legal custody. The court could just say, okay, someone needs to have sole legal custody so we don't have the issue. Both sides. How old is the child again?
8.
8.
And we have 4 other ones that are still at home. All the kids are in sports. It's not an issue with my ex-husband and his kids. It's not an issue with our girls. Like Z asked, why can't my dad be there? All the other kids' parents are there.
Well,
it's all the other ones do it. Why would we deny our youngest to do sports just because somebody doesn't want to take him to it every other weekend? It's not even regular. He doesn't take him to practice. All he has to do is take him to one game every other weekend. It's not about him. It's about Z. Why can't he do that and support him?
So why didn't the child go to dad April 26th or April 29th?
Because he set a time that didn't work for me and refused to work with me on a time. He went all by himself at 5 o'clock that day and didn't reach out to me the rest of the weekend.
That's another thing. 5 o'clock.
Just a second. I heard 5 o'clock. We don't have a time, do we, in the order?
No, it's always been.
Why can't we get a time?
Because both of us work. There's a time he didn't even have a vehicle.
No, I just want to know.
We don't have a
time. Can we get a time now?
Please. It's been 5 o'clock for years. 5 o'clock on Friday to pick up, 5 o'clock on Sunday to drop off.
If that works.
But it's been that way for years. That works for me.
Is that the time you're proposing?
It doesn't always work for you though either. So if you can't.
Time out. One at a time.
Yeah.
I'm asking for a time. Is 5 o'clock the time that works for you?
I can do 5 all the way up till 7 o'clock. Doesn't matter. So 5 o'clock, I can set it in stone. 6 o'clock, I can set it in stone. 7 o'clock, I can set it in stone. Don't matter to me. But it's been 5 o'clock for years.
Why couldn't we set a time that the 26th?
I tried. You guys have.
No, I'm trying to set a time now. 5, 6, or 7?
7 will work with us in case we have sports.
7 work for you?
Yes, sir.
7 o'clock it is. 7 p.m. is pickup and drop off time. And regarding that, because there is no time that is placed in the order, I can't hold someone in contempt for violation if you cannot mutually agree on a time. Now we have a time, so there's no excuse for it. Okay, that issue's done. Here's the issue I have. I read these messages you sent.
Breaking point.
I don't care if it's breaking point.
That's what I did on the normal.
Then, miss, please, I'm speaking here to Mr. McLean. Jennifer, I have the right to tell you to F off. I'm dad.
Yeah, because I've literally been casted out for months, for 6 months. My opinions don't matter. Nothing matters. Like, I can't keep doing this. I'm halfway tempted to just walk away. I don't want to be that guy. I'm a good father. I wouldn't be sitting in front of you if I wasn't.
Well, you wouldn't be here fighting for your rights to have your child too. I get that. So I find no reason or justification for what you put in those messages. And I'm also going to order relative to parenting time that fathers not to consume alcohol 8 hours prior to or during the parenting time. No illegal controlled substances, only prescribed substances as ordered by the doctor. Very simple. But regarding reading, I'm not going to read any further into these messages because they're just awful. I'm holding you in contempt for violation of court order relative to the communication. Is there anything you'd like to say at this time before I impose disposition?
It's just so much you take before you break.
I get it.
I'm just trying to fight for my right for what was on the court order.
If you want to break, go outside and yell and scream. Don't do it this way. Because on the flip side, there's always a chance that the child can see this too. Has he been held in contempt for this type of matter?
Yes, Your Honor. We were last here in October 28, 2022.
It was a 250, wasn't it?
Yes, it was.
Well, an alternative is jail. You don't want to do that, sir, do you?
No, sir, I lose my job.
Right. If it happens again, it's jail, $250 due to the front of the court by June 7th. Go ahead.
So is there a way we can tell if he's drinking or not? Because in all honesty, you cannot tell when he's drinking. You don't know when he is, and I'm not gonna keep putting my kid at that risk. If he can do that for a birthday party and he can do that at other times because he feels like it, I don't trust him for many reasons, and those reasons are because of his own actions.
The court order is the court order. You have to
That's what
follow
the court order was last time too.
And if he's found to be in violation of it, he's been warned next time he goes to jail. That's how we do it. I can't have a policeman at the door. I can't have the deputy come in and just submit a PBT at a moment's notice. If I could, I would. That's how we have to do it.
Okay, so if I go to pick him up or drop him off and I suspect it, I have that right to call?
You have the right to do anything you wish
Okay.
within proper legal authority. You're both free to go. This is time and date set for continued motion regarding custody, objections, and a show cause regarding contempt. Parties are present. Would you both please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Your Honor, on February 12th of 2024, a stipulated order entered granting the parties joint legal and joint physical custody of the 3 minor children with custodial time on a week-to-week basis with an alternate midweek overnight. On April 26th, the issue of custody and custodial time as well as child support was taken under advisement. The parties were required to do random drug testing with a chance to change, including a test immediately after the hearing on April 26th. A referral was made by the Friends of the Court office to a chance to change. And Ms. Benjamin tested on April 26th with negative results. She tested on May 6th with negative results. That was a makeup test from May 4th. She had called the hotline but failed to report for testing. She tested on May 13th with negative results, May 18th with negative results, as well as May 28th with negative results. Mr. Shumka tested on April 26th, negative for substances. It did come back positive for alcohol. However, there is no alcohol provision in the order. On May 4th, he failed to report for testing, but it was indicated that he did call the hotline at 2:43 that afternoon. On May 6th, there was a negative test submission. On May 8th, Mr. Shumka failed to report for testing after calling the hotline at 8:39 a.m. On May 17th, Mr. Shumka called the hotline but failed to report for testing. On May 20th, he was given a makeup test. However, at that time, the collector found him with a device and they had asked him, I'm not sure. The email that I received from Shannon McPherson said the above client came in at 5:32 p.m. to test. When the mail collector was observing the client providing a sample, he noticed the client had a device on him. Mail collector asked him to give it up and the client refused. And when asked, the client To provide a sample without a device, he refused, stating he didn't have to pee. Client stated that it was his pee from the morning to test that. He was advised that was not a chance to change policy. The mail collector needs to see it come from the bag. They asked him to fill out an admit to use form, which was refused to be signed because he stated he provided a sample. He was again told that is not a chance to change policy. The collector needs to see it come from your bag. On May 22nd, Mr. Shumka failed to report for testing and failed to call the hotline. On May 28th, Mr. Shumka failed to report for testing and failed to call the hotline. That was a rescheduled test due to the
All right, Mr. Shumka, what's going on here?
Well, I don't know what the device was because there was no device, but do you have the results from that test? I know I provided a sample.
Failed to report. That's not their policy.
Wait, what?
Your Honor, I actually.
I'm speaking of this gentleman. Sorry. Failed to report. Why haven't you been tested otherwise?
Well, I have a full-time job and I definitely have a lot more to do and not always in the area. I have a traveling job. I definitely go, out of town. I not always just basically up. I'm not just sitting around here doing nothing. I made multiple tests and that's more than enough.
Okay. All right. That's what the court's going to do. Based upon the motion for custody in this case, the court finds there's a change in circumstance, specifically the issues relative to substance use. The court had requested or ordered the parties to attend testing. Both parties somewhat did. Plaintiff did, negative results. Mr. Shumka, negative. May 4th, did call but did not test. May 6th was negative. May 8th failed to report. May 17th failed to report. May 20th, makeup test. Device was found, denied by the defendant. May 22nd, failed to report or call. May 28th, failed to report or call.
I do have.
Excuse me, sir.
I do have.
You're finished. It's a change in circumstance. Court finds that by preponderance of the evidence. Based upon that, the court is going to order a friend of the court's investigation relative to custody, parenting, out time and support. In the interim, at this point in time, the court is going to order that mother have sole fiscal custody of the minor child. However, that does not create an established custodial requirement. The child is not to be removed from the state of Michigan nor more than 100 miles from the child's current location. And father is allowed supervised parenting time. We need to know who the supervisor may be, and it can be on day visits.
How does that work? Do you expect me to not have a job? Like I have work orders and I have been out of state. I can't just test. How come when she went out of state, when she had to go on a work event, how come she didn't have to test them days?
I can answer that. Ms. Benjamin contacted the friend of the court office and we relayed that information to a chance to change that she was out of the area and she had a test immediately before and immediately after.
And I work 7 days a week and I still took tests. So
the allegation of substance use and failed to report.
Substance use?
Excuse me. Failed to report, failing to test indicates to the court, frankly, I treat them as positives. That's how we proceed.
Because I have a job, you treat it as positive?
Yeah.
When I have no,
sir, if you were court ordered to do something, I'm not going to argue.
I did do it.
No, you didn't.
Okay.
I find you didn't. Clearly, you didn't do it.
Okay, so, but the abuse at the house with our kids getting choked and abused and stuff, that doesn't matter.
If you want to file a motion on that, you certainly can. We can address that at the custodial hearing.
Okay, but
on an interim basis, I made my finding. This proceeding is closed.
Because I have a job, you can take my kids.
Your Honor.
When they don't even have a stable house to live in.
You don't want to bury yourself any further.
I have a question. Who would, you said there would be a supervisor, is it?
You need to have a supervisor.
Who would be the supervisor?
If parties cannot agree on a supervisor, you can submit a list to the friend of the court, and then the court will make a decision.
Okay, thank you.
You're both free to go.
Your Honor, there was a show cause filed for denied parent time against Mr. Shumka. Is the court wishing to proceed on that, or is the court wishing for that to be addressed with the investigation?
Be addressed with the investigation. This is petitioner's motion requesting a personal protection order. The court received initially a request for an ex parte personal protection order. Received on April 12, 2024. The court that I'm sorry, that was filed, well, written order, court denied the ex parte order and stated in part, court reviewed 73B District Court case number 24-152 SM. According to that file, the petitioner, Ms. Pratt, had been charged with domestic violence with the alleged victim being the respondent. Currently, the lower court has ordered petitioner to have no contact with the respondent. The terms include that petitioner not assault, harass, intimidate, beat, wound, or threaten the respondent. That petitioner not have or cause any third party to have any direct or indirect contact with the respondent or enter the premises or area of the respondent. Further, petition alleges information occurring in 2022 and 2023, with the most recent allegations of March 10, 2024, where petitioner alleged that cops were called after a huge confrontation, but nothing specific. As a result, the court had directed the parties, if they wish to, the petitioner to file a motion, which she has done in this case. S1 and then?
No.
Well, please raise your right hand.
Do you solemnly swear or affirm the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Sorry, I didn't hear you.
I do.
Okay. Ms. Pratt, the burden of persuasion, the burden of proof in receiving a personal protection order rests upon you, the petitioner. So explain to the court why you feel a personal protection order is required.
Over the last couple of years, just any time that we're out and about, he's instigating, he's threatening, he's making comments, rude insults. The last time that you're talking about that I saw Judge Harrington for the police to be filed or the police called, you know, you just can only take so much. So there were altercations.
When's the last time you claimed this happened?
That was in March. Just the stare downs as always and the name calling. And I mean, you can only take so much before he's had enough. And I threw my empty cup at him and there were altercations out in the parking lot. You threw a cup at him? It didn't hit him, but yeah, I threw it his way, yes. It was an empty plastic cup.
On March 10th?
Yes.
And is the domestic violence case pending right now?
I've already been to court.
Okay, it's done?
Yes.
What happened?
The judge just gave me 3 weeks probation.
Okay,
He
so-
threw out everything else because he specifically said, I will drop the no contact order so you can go file a probation, a PPO. The probation officer told me I should, Officer Flores told me I should, my lawyer told me I should, and Judge Harrington told me I should.
Okay, so there's no contact provision between you and Mr. Grady?
No, they dropped it.
It's dropped?
Yes.
Okay. Now, when was it dropped?
When I went to court, I don't know the exact date.
Was it after March?
Yes.
Okay. What has happened after what has happened after the temporary order from Judge Harrington was dropped? What contact did we have?
Nothing.
So, and again, I made reference that the petition that you originally filed involved incidents occurring in 22 and 23. Are you saying there was one incident in March 10 of 2024? That's it?
There's been many, but those are the ones I knew the exact dates for.
Okay. What
Instead
else?
of it getting less as the last couple of years went on, it's gotten more. I don't know if it has anything to do with who I'm seeing, but every time we're out and about, there's the stare downs, there's the rude comments, I mean, at times it's lengthy, at times it's just minimal, but I'm always looking over my shoulder, and I wasn't aware that I could file anything for this, but I've been told by everybody in the courthouse that I've seen lately to file them because they feel like this will never end and it's just going to continue.
Is he following you or appearing within your sight?
Just when we go out, if I'm at a local establishment, there's been a couple times where I've left and went to another one and then he'd be there.
When did that occur? This year?
Yes, January is one of the dates.
Why was that mentioned in the motion?
Should be. That was the day he said he had guns.
Any other justification or reason that you're requesting this personal protection order?
I just feel that it's always gonna happen. It's a harassment. It's constant. I don't feel it'll ever end. I feel like he's told people specifically that he won when he called the cops. He got what he wanted. He wanted me to lose my job, which I've been at for 16 years. And I feel like, because I didn't really get anything out of it, it's never gonna end. And I'm just here because that's what I've been told to do.
Okay. You wish to call any witnesses?
I mean, my boyfriend has seen it all the time. If he wants to speak, but other than that, I didn't bring anybody. No, I wasn't
That's
sure that I
up
could.
to you if you wish to call any witness.
Up to you.
Okay, in a moment though. Mr. Grady, you have a response to all this?
It doesn't happen. She follows me. I left Pete's Bar that day and went to Bottoms Up, and then here they come. And it's in her own statement. She said, I was sitting at the bar when she walked in the door, wringing my hands. Rubbing my hands. I rub my hands all the time because I deal with so many different chemicals that isn't fun.
Do you stare her down?
No.
Do you make rude comments to her?
I talk to the people that are sitting beside me and I say rude things about her, but she'll stand right there behind me.
Why would you do that? I mean, you're poking the bear, aren't you?
Apparently, she assaulted me.
Well, not apparently, she pled to it.
Right.
She's found guilty of it.
So if you ask me, the PPO should be the other way around. She should have to stay away from me.
Well, according to Ms. Pratt, the district court dismissed or removed the no contact provision.
Well, they probably did. I never pressed it. I never went out there. I didn't care what they did to her. I just wanted her to stay away.
You want to call your boyfriend?
Sure.
Sir, step up to the witness stand. Sorry, sir.
Well, I get to question him.
Absolutely.
All right.
Please raise your right hand. You have questions?
Do I?
This is your witness. You may proceed.
Did you witness Ron Grady saying multiple rude comments to me when we go out?
Yes, a few times.
When?
Well, one night, it was twice in one night.
2024?
Yes, it would have been probably January. We were at Bottoms Up Bar. There was a snowstorm that night. There wasn't many people in there. The bartender was actually telling him to calm down, that there weren't going to be any fights tonight. And he says, there, don't have to worry about any fights. I have guns. Well, she ended up closing early that night. So we all went down to Pete's. He had left before us, and then we went down there. And when we walked in, he was there at Pete's also with Art. And we sat down, and I was actually talking to Heidi Smith that night. He was getting really irritated with me. And they sort of just pulled me to the side and just said, calm down, you know, blah, blah, blah. And as he's walking out, he called her a worthless whore.
Were there any threats of harm or injury, anything like that?
No, just he just mentioned the guns that night, that he had guns. He didn't need to fight. He had guns.
Any other circumstances within 2024?
That night of their altercation, I was present for that.
But ended up that Ms. Pratt was charged with
Right.
assault.
Yeah, because he actually called her a whore that night too. We're facing, she got upset, and that's when she said,
Anything else?
no, just like I said, like what she was saying, every time we go out and he's around, he likes to do the stare downs and stuff like that, and yell stuff across the bar or stuff like that.
Cross-examination.
Oh, yeah. So where was you when Jessica threw the glass at me?
I was up at the DJ booth.
So then you didn't see me say nothing directly to her, because when that happened, was I not close to the exit door?
When I seen you, you were by the pool table.
That's close to the exit door?
Right where we were sitting.
There ain't no chairs over there.
We were sitting at the corner of the bar.
So then how did you see me if you was over there by the DJ booth? How did you see me or hear me say something directly to her?
I didn't say it. I seen when we were outside, you had said something to her. You were calling her a whore and everything else.
Was that when you were jumping up and down in the corner of the parking lot threatening to beat me?
I was trying to protect her.
No, you weren't.
Okay.
I mean, Your Honor, the only thing that should happen right here today, they should be even. If I am somewhere, they shouldn't be allowed to come in. If they're somewhere, I shouldn't go in. I never threatened them. I can't have guns.
Why can't you have firearms?
Because I did 10 years in the penitentiary. I can't, so then I'm talking about guns, we're talking about my biceps. I'm 61 years old and in pretty dang good shape.
Pretty what good shape?
Pretty dang good shape, I said. I wasn't gonna swear. No, sir. Nope. But, you know, and she follows me from place to place, like they said. I left the plaza and I went to Pete's and then here they come.
Can I say something, Judge?
Yes, you may step down.
I just want to say that I've had him blocked on all social media since the day we were divorced. I have no interest in following him anywhere.
And
If we run into each other, I can be civil, but the name calling is out of hand. They're stare downs, they're threatening with guns. He can deny it all he wants.
Okay. Sir, you can present proofs now.
She's still using my medical insurance. And here's proof. They're sending me the clean bills.
Anything else?
And I don't follow them around. It just doesn't happen. The night that happened, I left Pete and went to the plaza and then here they come. You know, if you don't want to hear my voice, I talk loud. Stay away from me. Not my fault.
All right.
Can we make her pay this medical bill at $800?
Well, that's a separate action. That's a separate. Let's talk about the BPO here.
Oh, it's gonna happen.
Statute requires the court to issue a PPO if the court determines that there's reasonable cause to believe that the individual to be restrained or enjoined may commit one or more of the acts listed. That is, the court has to consider all the following: testimony, documents, or other evidence in support or request for the PPO, whether the individual to be restrained or enjoined has previously committed or threatened to commit one or more of the acts listed. A court may grant a PPO if it finds reasonable cause to believe that the individual to be restrained or enjoined may commit the offense of stalking. The offense of stalking requires activity that establishes a course or pattern of conduct. To determine whether it's a course or pattern of conduct, the court must contemplate all relevant present and past incidents arising between the parties. The court now has a full picture. Because again, when this alleged blow-up occurred in March, the court had no idea what it was. But if you combine it with everything involved here, including the past years of the relationship, the court finds that a personal protection order is warranted, and the court will be entering a personal protection order, which requires Mr. Grady, that is, sorry, from the following: have to follow or appear within the sight of the petitioner, sending mail or other communications, approaching or confronting in a public place or private or on private property, entering onto or remaining on property owned, leased, or occupied by her, placing an object or delivering an object, property that is owned, leased, or occupied by her, appearing at her workplace or residence, and contacting her by telephone. That's it. This personal protection order will last May 24, 2025. Court will prepare the personal protection order paperwork and will proceed